It's a pleasure to be here, and thanks for this invitation and for giving me the chance to contribute to the debate and to bring my view on this topic, which is a topic I have been studying for several years, and now the MiCA, the markets in crypto assets regulation, seems to be a game changer. This is the point of my presentation. I will try to explain why. So for those people who are not so much familiar with the markets in crypto asset regulation, it is a regulation, this is an important word to remember, which was voted this spring and which is supposed to enter into force at some point between 2024 and 2025, because there are some regulatory standards and other regulatory instruments that need to be published before everything is in order. Anyway, the MiCA provides the first legal framework for crypto assets. And it is also important because it regulates, as my colleagues said before, also what are called crypto asset service providers. So it is a sort of it mirrors the MiFID in a way. It is something similar to the MiFID. And this is because the MiCA has a complementary role in the European financial landscape. It means that the MiCA wants to tackle those crypto assets which fall outside the scope of existing European financial legislation. So it goes, hand by hand with the MiCA in a way. So this is the main purpose of the MiCA, to provide some protection to investors, or better to say to people, buying those kind of products or services, and that they cannot rely on financial or even consumer law protection. But we will be back on that. So the question that I would like to address during this presentation is MiCA like a blueprint, meaning that according to commentators, MiCA is the first and only legislation of its kind in the world, which is true. And it represents a landmark regulation, it is true. And it will put an end to the crypto Wild West. I'm not sure it is true. And someone has argued that it will lead the way for other jurisdictions. So here we have even colleagues from the United States of America, and I'm used to go to Hong Kong to have such animate discussions with my colleagues there, because you know that the European Union is the best in producing laws. So they are looking at us, and they want to know if this is a good way to deal with this kind of problem. So are those sentences correct? I have some doubts, and I will try to explain why. The first thing I would like to point out is that there is a comparison. Normally, commentators, they tend to compare the European Union legislation with the US approach, saying that we have chosen to have regulation, so to have a legislative approach, and they are experimenting, on the contrary, a sort of regulation by enforcement, meaning that it is the Security and Exchange Commission which is defining what is a crypto asset, and which is trying to apply the same rules applicable to securities to security tokens, or tokens, because the Securities Exchange Commission is quite strict in interpreting what security is. But this approach has been criticized because of the limited predictive value of settlements, meaning that there is a lack of clarity. So we have two examples of regulatory approach, and we know that there is a great debate on how to deal with crypto assets regulation. But we have two clear examples of European Union, the European Union choice to deal with some legislative and prescriptive regime, and the US and the choice to leave the stage to the Securities and Exchange Commission and not to have new rules devoted, bespoke regime for crypto assets. What I will try to demonstrate in this short presentation is that this approach, comparing the two realities, is in a way it's false. I mean that if you look at the MiCA in an attentive way, you will find out that it is much more similar. The situation that the MiCA leaves to us is much more similar to the US than what it seems at the first sight. So the MiCA has a lot of objectives, but the most important is to provide greater legal certainty. So the regulatory, regulation by enforcement lacks certainty, according to some commentators, and MiCA should instead provide greater legal certainty, which means that it should provide for a comprehensive complementary regulation and reduce fragmentation. So we are expecting to have this kind of result after the MiCA will come into force. And of course, the backbone of this architecture is the concept of crypto assets. So what are crypto assets and what are crypto assets according to MiCA? The problem and the reason why I don't think that this objective will, or these more specific objectives will be met, is that the taxonomy is nor certain nor uniform. So at the very end of this presentation, my take-home message is that our situation in Europe is similar to that one in the US, despite the approval of the MiCA, and that it is not going to be better after the MiCA. So starting from the taxonomy, it is something you already know, what is a crypto asset according to MiCA, and that we have three main categories of crypto assets according to MiCA, and each of them has a different regulation as regards, for example, the duties of the issuer. But these definitions have been changed a lot of times. In particular, for example, utility tokens now means a type of crypto asset that it is only intended to provide access to a good or a service. It is no more written that that good or service should be available on DLT. It is no more written that that good or service, the utility token should be accepted by the issuer and not from other people. It is supplied, the good or the service is supplied by the issuer, but the utility token can be accepted also by other persons. And it is no more written also that it is for purposes other than financial and payment. So a lot of revision, and this is the final text, and it seems to be a wider, approach. And unfortunately, the more wide you are, the wider you are, and the more generic you are, at least. So what we can say is that for sure, crypto assets contain the definition also of Bitcoin, because crypto asset means a digital representation of a value. And the value there, if you read this article 3.5, in connection with recital 2, you will understand that in crypto assets also cryptocurrencies like Bitcoin are included. So in a way, this seems to be a good architecture. I mean, we have crypto assets, which are both cryptocurrencies and tokens, and then we have some some categories. But what is important to focus on is exception. Because the first exception is that this regulation does not apply to NFTs, and it does not apply to what is security token, so crypto assets that qualify as financial instruments. So the MiCA says, I will not deal with those categories of security tokens and non-fungible tokens. So there are two categories of tokens which are outside the scope of the MiCA. The problem is that we are not able to distinguish what is a security token and a non-fungible token just simply reading the MiCA. And there is something even worse. So I will demonstrate that the MiCA will not bring more clarity nor more harmonization, making three examples. The first case is related to security tokens. So security tokens are out of the scope of the MiCA. The problem is that financial instruments are described in a directive, meaning that there is no regulation, that member states can have different approaches to what is a financial instrument, meaning that it is not something really predictable what a financial instrument will be, and so whether the MiCA will be applicable or not. So we will have lack of predictability and fragmentation. Of course, this is something the Commission and the Parliament knew, and they tried to fix this problem as much as it's possible, saying that the European Securities and Market Authority should issue some guidelines. So here, in my opinion, it's not something completely different to what is going, what happens in the United States of America, because even there is the National Securities Authority who has the who is in charge for deciding whether something is a security or not. So at the first sight, it seemed to be completely different, but then you see that everything is similar. And what is worse is that, according to Articles 8 and 18, is up to the issuer to demonstrate that that token is not a security. So this is not good for clarity and for legal certainty or whatever. And this idea that we are going to maintain some fragmentation is also evident from this Article 97, where it is told that the authorities, European authorities, shall try to reduce fragmentation to the extent possible, meaning that we will maintain some sort of fragmentation. Okay, so then the second example comes from utility tokens. Well, the utility tokens, they are covered by Title II, meaning that there are some obligations for issuers and other stuff. But this title, so utility token, will not be included in the rules for the issuer if the utility token concerns a utility token providing access to a good or a service that exists or is in operation. Meaning that if an issuer wants to issue crypto assets providing access to a good or a service that exists, then no duties of MiCA are applicable to that issuance, unless it is listed. So the question that I want to address here is, are we sure that the MiCA is a complementary regulation? Because what about this kind of issuance? It is not covered by MiCA, but does it mean that it is covered by consumer law? And in Recital 29, it seems to say yes and no, because it is written that we know that there are some exemptions, and we think that they should be covered by consumer protection. And there are some some directives which are mentioned. But what about Directive 2011, the right of withdrawal? Can we think that when there is a crypto asset, a utility token, which is not covered by MiCA, we can apply this kind of regulation or better directive? The problem is that it is not easy to apply this kind of rules to tokens, because there are some rules that might not be suitable for crypto assets. For example, can we think that crypto asset utility token is a sort of supply of goods for price dependent on fluctuation, so it is covered by this kind of exception? And what does it mean that you can exercise your right of withdrawal, that the trader shall reimburse using the same mean of payment that you used? Because if I bought that token with cryptocurrencies and then the cryptocurrencies has changed the value, and I can have this withdrawal and get the reimbursement for a smaller sum of value. I mean, so I think that the MiCA is not clear in defining what's its position between financial law and consumer law. It seems to be too close to financial law and too close even or too far from consumer law, and the borders are not very clear. And the third example, and the last one, is related to NFTs. NFTs are considered out of scope because of what we read before. But the problem is that we don't know actually what are they. So in Recital 10, it is written that we need to understand better what are they. And this should be done by, again, the European Securities and Market Authority. So again, the role of defining the borders of the MiCA is left to the authority, like in the US is. Now, I think my time is over, but if you want to understand what is an NFT and what is not, this is an important decision that we have already being able to read from the Securities and Exchange Commission in the United States, and that this is an important case, in my opinion. I suggest it worth reading. And this is the last important slide I would like to show you, that it is left to ESMA to decide with the guidelines where crypto assets that are considered unique and non-fungible might qualify as financial instrument. I think that this final sentence is, like shaking the MiCA and say, we don't know actually what's going on, because they didn't say we will decide if an NFT is a utility token. They said we will try to assess whether an NFT is a financial instrument. But how can an NFT, which is normally, it gives you access to something, so it's a utility token, normally said, is a financial instrument? So I think that there is a lot of confusion in the project of the MiCA, and it took a lot of time to arrive to that kind of compromise text. And I think that it shows that it is a compromise, because everything is still left to the authorities, to guidelines, to courts, to interpretation. So it is a starting point, and I'm not think that this starting point is so far from the approach the United States are experimenting right now. Thank you.
So thank you. I will start my presentation. And first of all, I would like to notice what I will briefly represent what artificial automatization tools do we have in Lithuanian tax administrator, and later I will show you some principles, what taxation basic rules we have on personal income tax when you have some individual activity or some occasional transactions connected with crypto asset. So first of all, there you can see Lithuanian flag, and Lithuanian flag consists of tricolor horizontal of yellow, green and red. Why I speak about national Lithuanian flag? As a consequence, national researchers in Lithuania disclose that the most important three elements for the taxpayers while receiving tax services are like three elements, like three colors of national Lithuanian flag. So it's speed, simplicity, and clarity. And as a consequence, these three elements can be reached by applying some special tools like artificial intelligence, also automatization, robotization process. So I will briefly represent what tools we have in Lithuanian tax administrator, and these tools could be useful to find or to get some information about taxation questions on crypto asset. So first of all, we have automatic process of taxpayers identification. Taxpayers identification can be done now by three methods. Firstly, by the phone number. Secondly, if two or more taxpayers are using the same phone number, they can be identified by the concrete PIN code sent to this taxpayer, and also they can be recognized by mobile signature. So this kind of technologies now we applied in State Tax Inspectorate, and identified clients can receive services faster and more conveniently. Why faster and more conveniently? Because if you are identified client, so you have a priority in call line, in call queue. Also, you do not have to ask additional questions for the purpose to identify you. So, for example, if you have questions how to tax crypto asset, should I pay VAT, what principles we have on corporate income tax, etc. So if you are identified, you can get this information faster and more conveniently because you will get the priority in call queue. And the process is very simple. You just have to register, just to write your cell phone number in our internal system, and you will be automatically recognized. So because this conference is also connected with some technology equipment, so I will briefly represent. Yes. Oh, okay. So show by this one. Yeah, thank you. Also, we have customer risk profile system. What is customized risk profile system? It's an internal system which discloses if a taxpayer is yellow, green, or red. Green means that a taxpayer is clean, he has not any legal obligations to do, for example, on crypto asset taxation. Yellow color discloses that a taxpayer has some legal obligations to do in the future, and red color discloses that a taxpayer already has an inappropriate behavior, that his criteria are bad. All these criteria are divided into payment, declaration, behavioral, and registration criteria. For example, you have individual activity on crypto asset. Did you submit your annual tax return on time? So if not, on this criteria, you will get a red color. If yes, you will get a green color. So to sum up, this internal system works like as a traffic light. The principle is the more red color you have, the more maybe problems you will have in future with your legal tax obligations. And during the phone call, if you are calling and you are trying to reach the information desk of State Tax Inspectorate, our tax consultants has the ability to see customer risk profile. For example, you are calling just wanted to know what VAT principles is if you are having some Bitcoin or Ethereum transactions. But our consultants can see that, oh, you didn't register your individual activity on crypto asset. So he can remind you other legal obligations what you should do. Also, we have other tools. For example, we have situations in state tax inspectorate that sometimes taxpayers have the questions connected, for example, with social contributions, with labor law, or other questions. So Lithuanian tax authority has direct call forwarding to another institution. So we call it one window principle. That means that you do not have to call again, for example, to the social insurance. You will be direct call your forward to these institutions, and by one phone you will get all the necessary information. Have someone on you tried to register individual activity? It's a question, and to show what documents do you have of your, for example, purchasing transactions of crypto asset. Have you ever to show this income on your personal income tax? Has anybody registered individual activity? Nobody shows. Don't worry, it's just consultation presentation. And what is co-browse function? In simple words, if you are identified client, you can apply for co-browse function. In simple words, in your computer screen during the phone call, you can see what our tax consultant is disclosing, showing for you. For example, you have no imagination how to submit some documents, acquisition price, for example, from Binance, Kraken, or some crypto exchange. So co-browse, when you apply to this function on your computer screen online, you can see what our tax consultant is showing to you, which documents you should switch and fill. So this service, it allows to fill out the necessary documents remotely with a tax consultant in real time during the phone call. So it's also, I think, useful element. Just some short sentences. We have machine translation function. If you do not know what taxation principles we have, all the necessary information you can find in English, Russian, and Ukrainian languages. For all the questions like double tax treaties, VAT, personal income tax, etc. So you just can click which language you need, and all the web page information will be automatically translated by, for example, English language. Also, we have a robot, automative robot. Yes, it's not a human being, it's a robot. We call it automatic call. How it works? Imagine you have a nice morning, you're sleeping, and your cell phone is ringing, you answer, and a robot from State Tax Inspectorate reminds you to submit your annual tax return on time. So when you have a very nice, magnificent day after this call. So to sum up, we have such a function, automatic call. It's a robot which is calling to the taxpayers on some specific questions to remind their legal obligations. And we think it's really economical, convenient, and efficient solution because it can reach taxpayers which are not using electronic services, or it can reach very fast taxpayers which are using electronic services, but they cannot find some information, or they are not reading the email saved by tax administrator. And we counted that this robot is really useful because our internal accounting system shows that we have this robot approximately 2 years. So from the installation of automatic call to the present day, we have approximately 2 years. So it saved us more than 677 working days per employee. So now some lawyers maybe will look other job because some of them just do not have what to do because we have this automatic call robot. And also there you can see two diagrams. So very shortly, the first diagram discloses the number of automatic call campaigns. Call campaigns is a different topic by which automatic call can call to you. For example, if you use your car for the private sector, it can call and remind you to disclose what you maybe have to pay as a fringe benefit taxation payer. Also, it can remind, for example, if we see from some documents or we notice that you have some individual activities, for example, in future from crypto transactions, so also this automatic call could call for you and remind that, dear sir or madam, you should register your individual activity. And also we have the second diagram, automatic call quality. It discloses the effectiveness of automatic call. Effectiveness means that it shows the number of customers who have successfully received an automatic call. So we have a function, if this robot cannot reach you at first time, it can repeat a call, for example, after a day or after 1 week. Also, in addition to this, we have another robot. This robot has his interface. You can see him, and he has a name. His name is Simas. We have some internal voting what name he should have. And this robot Simas works as an artificial intelligence system program. It's a chat box. You can chat him, you can find on our main website of State Tax Inspectorate, and you can ask him some questions, and he can bring you the most appropriate answer on some topics, which he can bring some information. He speaks in Lithuanian and also in English language. We are spreading his knowledge, and we think that he really allows and creates the image of an innovative organization because it improves the availability of information, and it can increase the efficiency of the tax information center because we counted that it has also some saving of works. I mean that just to compare, a normal human body, a human being, can answer, it's approximately, it depends on what different question is, but approximately between 1,000 and 2,000 chats per month. And Simas can answer all the chats which we have per day or per month, but now he specializes on special topics, so he usually answers approximately between 7,000 and 8,000 chats. So we can save approximately 3 or 4 employees which are working with chats consultation. And Simas, of course, works 24 hours per day. He's unstoppable. You can write him on early morning or on day. He always can answer you, not like real State Tax Inspectorate, because we have working hours. He do not have. And also he specializes, as I mentioned before, on some topics like individual activity, business licenses, also income taxes, real estate, and other popular questions. And it has the possibilities to start a real conversation if he do not know what to answer. For example, if you answer Simas, I would like to register individual activity because I sold all my Bitcoin, Ethereum, Cardano, etc. What personal income tax or social contributions should I pay? Or should I register it individual activities? So of course, that kind of question Simas will answer. He understands that. But if you ask him some scientific problematic questions, for example, what timing or permanent differences do we have in Lithuania between legal regulation of financial accounting or corporate income tax? Simas will think a few seconds and he will start conversation with our real tax consultant because he knows some special topics. And as I mentioned, it has artificial intelligence system because it can bring you the most appropriate answer you need. He works in simple words like a spider net because you can ask the same question in different words, but this artificial intelligence system, it understands the main idea, the main question, what do you have? For example, your key question is or personal income tax, or other some questions, for example, tax rates. So he understands from your different words of questions what the main idea of your question is, and he can bring you the most appropriate answer. And what is more, he can also send you online links, visual materials, some presentations. He has not only chat function, but he can send you what all the information we have in our website, some useful presentation, or he can forward some PDF file or picture which is showing information connected to your question. And the last thing before some information about crypto taxation is that we robotize the process of administrative responsibility for late reporting or non-reporting. So the process in Lithuania is very simple. If you do not submit your tax declaration at first time, so you will get a warning, but if for the last 12 months you will continue and do not submit again other forms, so you can get then an administrative fine. And now we have a robot which is working with these protocols. And just to compare, when we do not apply robot, to prepare one protocol, it took 1 hour 40 minutes. Now robot can prepare this protocol during 5 minutes. So it's really useful, and all the process, it's PS assessment, preparation, and dispatch to the taxpayers. All this process of protocols now is done by a protocol robot. Also some machine system which is just writing and sending protocols. But for you it's not interesting information, because if you have some legal obligations on crypto asset, of course you will do on time. And now some briefly information. So how we tax crypto asset, because I have limited time, so I just present usually the most popular question, personal income tax for individuals, which is the most popular question in Lithuania, which we can see identify from questions. So the principle is very simple. There could be identified 2 methods. If you, I just will explain in simple words. If you manipulate your crypto asset or Cardano or Bitcoin, it doesn't matter, every day or every week or usually. So when we recognize what you have an individual activity which you have to register. Later I will show how we tax or how we calculate personal income tax on individual activity. But if, for example, you bought Bitcoin for a long term, you are keeping it and you will sell it maybe after 2 years or after 3 years. Also you bought some Ethereum, also bought some Solana or other crypto assets. You're just keeping them, you have maybe 2 or 3 transactions per 1 year, or you just sold a part of that after a few years. So it won't be individual activity when we say that just is your income from the other asset. So how to tax? What is the differences? First of all, if you have individual activity, it must follow 3 criteria. It's continuity, operational autonomy, and of course your purpose should be to gain income and profit. And if you have some occasional transactions, which I mentioned before, you just have 2 or 3 transactions per year, then it won't be individual activity. And now how we are calculating personal income tax. So the principle is very simple, because sometimes when you read personal income tax law, some students said, I didn't understand anything. Can you explain in simple words? So the principle is very simple. You, from your selling price, you have to deduct your acquisition price, your purchase price, and if the result does not exceed 2,500 euros, it won't be taxed. And if this amount, this result, I mean profit, will exceed this amount, so the exceeding amount of 2,500 euros will be taxed on personal income tax by 15 tax rate. And by the way, we have progressive tax system in Lithuania. If your amount will be more than 180,000 euros, so the exceeding amount will be taxed at 20% tax rate. So that is the main principle. And the other question, if you have individual activity and you have to register it, first of all, from your income you have to deduct your costs. Cost deduction can be done by two methods. You can deduct your actual operating expenses, or you can choose a simple method and deduct the amount equal to 30% of your generated income. And then on one or another method, the principle is the same. If you, from your income, deduct your expenses and your result per taxable period per 1 year does not exceed 20,000 euros, so the personal income tax rate will be at 5%. If it exceeds, we have a special formula, we call it tax credit, application of tax credit method. And when your tax rate, if amount will be from 20,000 euros till 35,000 euros, can increase from 5 till 15 personal income tax rate. And finally, if this amount will be exceeding, so when you just have the fixed personal income tax rate of 15%. So it's just a basic information, but these are the principles how we calculate personal income tax. And of course, if you need some information, you can always ask SIMAS, or you can write all the necessary information you can find on our main webpage in English. And we also have some special commentaries written in English form, what principles we have on taxation, not only on personal income tax, but also on other taxes. So thank you for your attention, and I hope that you do not have some problematical questions, because it's really easy when you understand the system. So thank you.
Good afternoon, everyone, and let me start by expressing gratitude for the honor to be the part of this great event. I would like also to thank Neringa Gaubienė for the invitation to this conference. And today we will speak with my colleague about the cryptocurrencies, exploring threats and embarrassing possibilities. And Edvinas will speak more about practical side, and I will speak about the more theoretical side. I'm associated professor at the Vilnius University, but today with my colleague, we are together also from our law firm. We are partners and attorneys in the law firm Edvinas Meškys and Partners. How I said, our presentation consists two parts, theoretical and practical part. So I will speak more about these questions like, is cryptocurrency a protection against state interventions, or the concept and legal status of cryptocurrencies, advantages and disadvantages of cryptocurrencies. And Edvinas will speak about the liberalization without state intervention, impact on consumer rights, and impact on criminal procedure. And also Edvinas, like attorney, will give some practical examples of this topic. So let's start. With first question, is cryptocurrency a protection against the state intervention? And I would like to say that I teach constitutional law at the Faculty of Law. So let's start with this branch of law. And our constitution, Article 46 of the Constitution of Lithuanian Constitution, enshrines the freedom of economic activity. And according to the large doctrine of the Constitutional Court, this freedom means also the freedom of contract. So every person has the right to choose with whom he would like to have a transaction, and for that he would like or she wants to conclude a transaction, except for prohibited objects. However, Article 46.3 of the Constitution states that the state has the right to regulate economic activity in such a way as to serve the general welfare of the nation. Thus, the economic relation between entities must be in the public interest. So, emergence of cryptocurrency in 2009 and the first transaction using the cryptocurrency Bitcoin in 2010 may fundamentally change the understanding and implementation of this constitutional provision. It may be irrelevant. Why? Inspired by the work of author Stuart Brand, the cyber libertarians wanted to free themselves from bureaucratic power or from state's power to create a world free from prejudicial privileges and unnecessary legal regulation. And cryptocurrency has become like one manifestation of this freedom. So it is associated with the financial independence of the individual from the states. Cryptocurrencies such as Bitcoin are decentralized. They are not regulated or controlled by state institutions. And this enables people to store and manage their assets without direct government intervention. So we can say that Article 46.3 of the Constitution seems to become irrelevant. To anonymity and cryptocurrency holders and impossibility for the state to influence, to regulate the use of these assets raise also a number of other questions. For example, is such decentralization and anonymity of economic relations not contrary to the law? And we have here a big problem because in Lithuanian law, we don't have so many researchers about these topics. But I'm glad that, for example, economic researchers, for example, like Subačius, Subačienė, Cherkesas, they wrote some articles which are also interesting for lawyers, because we have no other articles or research. So let's move then to another topic about the concept of the legal status of cryptocurrencies. How I mentioned, cryptocurrencies is an expression of economic liberalism, and according to statistics, there are currently more than 90,000 cryptocurrencies in existence. But still we don't have a concrete definition, and today we heard about a lot about this information, and we don't have a regulation, the specifically regulation for cryptocurrencies. So also in this situation we can see to the legal theory, and legal theory refers that cryptocurrency is a digital asset at the same time as a payment system which is seen as alternative to state-issued money. I can also say that in Lithuania we don't have a regulation about the cryptocurrencies, but cryptocurrencies are recognized as property under the Civil Code of the Republic of Lithuania. Civil Code provides that the subject matter object of the owner right may be things, or other property. So the property can be tangible and intangible property. In the legal doctrine, also from for author De Julis, this provision is identified as one of the greatest achievements of Lithuanian civil code. For example, the German or Dutch civil codes provide that only tangible objects can be the object of a property law. So cryptocurrencies, therefore, do not fall within the sphere of the regulation of these legal acts. Can we say that cryptocurrencies are money, electronic money? We have also a lot of theories, but let's see to the economic theory. And economic theory suggests that a currency traditionally has three rules. First, a unit of exchange, a second, a store of value, and third, a unit of account. So the following aspects need to be considered. What is the difference between a state currency and cryptocurrency? So we also heard today that a state currency have value because they are accepted by the public authorities and we can pay taxes with these currencies. And cryptocurrencies, however, they are not authorized by state, but they have value. And this value depends from the consumers. The growing number of consumers are accepting cryptocurrencies as a form of payment, although cryptocurrencies are not used to pay taxes. So what is the legal status of cryptocurrencies? That is also a very difficult question, but I will try to answer this question based on the opinion of international and national institutions. For example, European Central Bank has considered that cryptocurrencies are unregulated digital money. German Ministry of Finance has recognized bitcoins as private money. Following the opinion of Lithuanian Central Bank, a virtual currency is unregulated and uncontrolled digital money that may be used for payment, however put into circulation and guaranteed not by a central bank. However, cryptocurrency, according to our central bank, cannot be identified with electronic money, which is regulated by specific Lithuanian law. So we can say that international and national institutions recognize cryptocurrency as a payment instrument, but not as electronic money. But there is also another function of cryptocurrencies, and they can also act as securities, how Claudia today said. And for example, Bitcoin has risen out dramatically in the value in just 1 decade. So as a result, cryptocurrencies can be like an investment instrument. Also, legal theory identifies the following features of cryptocurrencies as securities. First, a person buying a cryptocurrency has expect to make a profit, and second, the success of the the success of the investment depends on the effort and work of other entities. So let's move to another topic about the disadvantages and advantages about the cryptocurrencies. Let's start with disadvantages. And the first disadvantage is there is no specific jurisdiction that control cryptocurrency transaction. We heard a lot of theories today about this disadvantage. I would like only to say that this characteristic is referred in a legal theory as irreversibility of payment, the impossibility to refuse a payment. So in the case of a false cryptocurrency transaction, the beneficiary is not obliged to return the money. What does it mean in practice? That means that the state or courts cannot oblige the beneficiary to repay the cryptocurrency received. So we can see that the state cannot intervene in this economic relation area. So this provision of Constitution 46.3 is irrelevant. The second disadvantage is cryptocurrency accounts are anonymous. So users can have as many online wallets as they want, and also cryptocurrencies have become a new way to avoid taxes. So we heard also about it. And the third disadvantage, negative environmental impact. We hear a lot of information about the green economy, green course, and so on. So we can also hear about the environmental activism, and they argue that cryptocurrency mining and transaction can use huge energy resources and have a negative impact on the environment. I have listed here the disadvantages that are more relevant for the public interest, and now I will list the disadvantages that are important more for individual users. For example, price volatility, and the prices of these currencies are unpredictable and can rise or fall very sharply. And in this slide, you can see that, for example, in 2010, we can buy 1,000 bitcoins about for $100, and now for $60,000, and it was particular price spike in 2017, 2018, and peak was in 2021. Also, a big disadvantage is security risk. About this disadvantage will speak also my colleague. I can say that public authorities also in Lithuania have not so much possibility to protect the consumers from such crimes. They don't know how to do it, and they have not so much information about. According to statistics, most of the litigation in the courts concerning cryptocurrency transaction is related with fraud. And the last disadvantage, which I would like to mention, regulatory volatility, and that is also a big disadvantage, because we don't know how this new relationship will be in the future regulated. For example, we know that these economic relations with cryptocurrencies are banned in China. So maybe in Europe we will not have a banned economic relation, but maybe it will be restricted more transactions like today. And now let's move to the advantages of cryptocurrency, and I will say that I have more disadvantages like advantages, but still we have a number of cryptocurrencies that are increasing, so we have also advantages. So the speed, international transactions are much faster with cryptocurrencies. Accessibility, who has internet, they can work and have cryptocurrencies 24 hours a day and 7 days a week, and without any interruption. Cheapness. Many cryptocurrency transactions are not subject to traditional financial intermediary fees, so this can reduce the overall transaction cost. And it is very important because, for example, in 2015, statistics showed that miscalculated bank fees amounted to around $141 billion in the world. So I think cheapness is also very important. And the last advantage, confidentiality of transaction, is also very important to those persons who value the privacy and anonymity in the financial transaction. So with this advantage, I would like to conclude my presentation and invite my colleague to present more practical situation in this topic. Thank you.
As a practitioner, I couldn't resist thinking that I'm still had the researcher in me, so I was listening to all your presentations. So some conclusions, you know. There is an attempt to regulate this sphere, but MiCA still doesn't know about everything, right? Although tax inspectorate is ready to tax you already. But we also have the advantage that we keep anonymous transactions, so we have some possibilities. But jokes aside, I'm always the one who likes this liberalism. And but we still have the question, should the state intervene at a certain point? And when we have the clients, we understand that they are very happy to use new technologies, they are happy to use cryptos, unless something happens. And you know, they always say, well, we have this freedom, we can do whatever we want, so please don't intervene. We can do whatever contract we want and in any possible shape we want. We can transfer cryptos and pay for the services. But then, what if something goes wrong? You know, I used the service, and somebody told me, please send cryptos to this account. And it happened to one of our clients. What impact does it have for our rights? Both like civil rights and criminal rights, are we protected? And then when we talk about the crypto, we say, okay, it's very safe, it's very secure because it's on blockchain. And blockchain is a ledger you cannot impact. But is this the truth? Because we already have some cases where it was overturned. Someone hacked some of the servers, and in a way they changed the logs. So something what was very safe appeared not to be that safe. So from contract law, we go to the court hearing, if we are successful. So let's move to two possible scenarios. So one is the civil impact, civil procedures, and then the criminal procedures. So you see here the consumer protection, but it's not only about that. When I was trying to analyze some court cases, of course, most of them are related to the United States, and I see that as in any possible jurisdictions, any possible spheres, we have some trends. So it says that we need to stop, right? Sorry, so I'll use some 1 hour and we are done. So the trends goes from, I wouldn't say those are really cryptos because it was related with the disputes when somebody was promising to bring the equipment to produce those cryptos, and they didn't, or the specifications were different. Then all the litigations changed to actually how to tax the cryptos and how to treat them. So whether those are securities or the payments. So two famous cases where we had Silk Road and the guy who created this, he said, this is not the currency, right? It's not money. It's something different. We can pay with that, but it's not. So it really depends how it evolves. And now it goes to consumer protection and what happens with all the collapses of market exchanges, crypto exchanges. And, well, the recent one, FTX, which was one of the biggest. But they started the class actions. And besides that, when more than 23 billion was wiped in a few seconds in that exchange, so the class action started even against those who were promoting the exchange. So for example, Shaquille O'Neal, Giselle Bündchen, and so on. So many people. So they are related, and those litigation trends will go on and on. And here, from the civil perspective, we had a couple of clients. They say, look, we had a transaction. It's a usual civil case. And what should we do? And it appears that there are so many practical problems. So one of that was you're not protected as in the bank, right? For example, we had this, yes, 1 minute? Okay, so let's make it very fast. So you don't have the coverage if you lose it. You cannot revert it. You cannot say, sorry, it was a wrong wallet. I didn't intend to send the money, but please send me back. There's no one to ask. You have to, well, somebody can see that you had the transaction, although they don't know you, but it doesn't help you because in order to provide the claim, you have to provide information about who was the other party. And institutions don't care. I mean, they say either it's your turn to bring the evidences. And well, and consumers don't even know the risks. What is the hot wallet? And that if you keep on the hot exchange, well, it's your problem. Those small terms and conditions, they say that's your fault. And then we have the criminal impact. And you know, one term is called pig butchering, which is a scheme when you actually feed the animal and then you butcher. So this is the same with the fraud, you know. So we had a client, and he wanted to invest, and he found the internet forum. And they said, well, look, this is a nice opportunity. Please, well, transfer cryptos. And he said, I don't know how to do that. They said, don't worry, we're experts. We're going to help you. And, well, as you can imagine, he get this. Your Ethereum was successfully withdrawn. And that was the first transaction. There were like 20 of them. And I said, well, okay, let's go to police. And we have clear case. And the police said, well, you know, these are like civil proceedings. You wanted to do something, so it's like not criminal thing. And I was like, good lawyer, going to prosecutor, you know, to claim. And then they say, well, okay, nice. What do we know? So the victim is from France. They had those fraudsters writing in French and then English, and they say, okay, in order to have the jurisdiction in Lithuania, you have to prove that it was in Lithuania. Well, it happens somewhere. We had the traces that it was maybe transferred through Lithuania, and then or you have to say that these were Lithuanian citizens or someone related to Lithuania. As they speak French, of course, they are not Lithuanians. So now the prosecutor said, sorry, well, we cannot start the investigation because we don't have any jurisdiction here. So now it's in the court. I hope that the court would turn the decision upside down. But this is the problem, and there would be even more. So the conclusion would be we can have the finest regulation, but if the institutions do not understand how to act, there would be a problem. So, but for the lawyers, there are many opportunities on work. So thank you so much.